Welcome to Guardianship 101, Person, Property, and the Law. This is a critical topic for both law students preparing for the bar and laypersons seeking to understand the protective mechanism of the law. Guardianship is not merely a formality. It is a trust of the most sacred character, entrusted by the courts to protect those who cannot protect themselves. Substantively, this legal doctrine is rooted in the doctrine of parens patriae, the state acting as the parent of the nation. We appoint a guardian because the law demands protection for the vulnerable. In any guardianship, we have two key parties: the ward, which is the person protected, and the guardian, the one entrusted with that care. A key distinction is between legal guardians, such as parents under the family code, and judicial guardians, who are appointed specifically by the court under the rules of court. For bar takers, knowing who qualifies as an incompetent is a must-know area. Under Rule 92, the definition is specific and includes several categories of persons. The incompetent category includes those suffering from civil interdiction, hospitalized lepers, and prodigals, those who waste or are likely to waste their estate through excessive spending. It also covers the deaf and dumb who cannot read or write, and those of unsound mind. Crucially, unsound mind applies even if the person experiences lucid intervals. Finally, any person who, by reason of age, disease, weakness, or any other cause, is incapable of managing their property will fall under this classification. Procedure is vital in guardianship. For minors, we follow Administrative Matter Number 030205SC, and for incompetent adults, we look to Rules 92 to 97 of the Rules of Court. The process begins with a petition filed in the appropriate court, Family Court for minors, or RTC for adults. The court must issue notice and conduct a hearing, notifying the ward and all interested relatives. The guardian is typically required to post a bond to secure the faithful execution of their trust. Upon approval, the court issues letters of guardianship, which serves as the guardian's official authority. Once appointed, the guardian operates under three main responsibilities that we call the guardian's three commandments: care of the person, management of property, and strict accountability. The first duty is care and custody. The guardian must provide for the ward's health, sustenance, education, and all necessary provisions. Secondly, the guardian must manage the estate frugally, taking care of the property entrusted to them in the most prudent and careful manner possible. Finally, accountability is non-negotiable. A guardian must file a complete inventory within 3 months of appointment, and an accounting of every cent and property annually thereafter. Pro tip for bar takers: a general appointment is not a license to sell or mortgage the ward's property. The guardian must secure a specific court order for any such disposition. The shield of guardianship is not permanent. It is lowered when the initial need for protection disappears, leading to termination. The two clearest termination events are when a minor ward reaches the age of 18, or, sadly, upon the death of the ward. Guardianship over an incompetent adult is terminated when the court finds that the ward has regained capacity and is now capable of managing their own property and personal affairs. Now, let's go to the famous cases involving guardianship, where the court clarified the gray areas of the law. Does a guardian have to live in the same house as the ward? In Abad v. Bayesand, 2013, the SC clarified that the person must be within the jurisdiction of the court. Why? So the court can actually reach out and touch them if they misbehave. While in Vansel v. Belms, courts won't appoint a non-resident alien as a guardian because they are outside the Philippine court's coercive power. Is the sale of the ward property by the guardian without court's approval valid? This is the most litigated area. In Heirs of Malate v. Gamboa, 2022, the SC reiterated, a sale of a ward's land by a guardian without prior court approval is void. It doesn't matter if the price was fair or if the guardian meant well. Protection of the ward's hereditary rights is paramount. Can a father, by the mere fact that he is the parent, validly sell the real property belonging to his minor children without court approval? In Neri v. Heirs of Haji Yusuf Oy, 2012, the SC taught us a lesson about parents. Even if you are the father, you are only a legal administrator of your child's property. If that property is worth more than 2,000 pesos under the old civil code, or now 50,000 pesos under the family code, you must post a bond and get court authority to sell it. Without it, the sale is not binding on the children. What happens if the guardian or the ward dies while the case is on appeal? As seen in Abad versus Biasan, the death of either party extinguishes the guardianship. The case becomes moot and academic because the juridical tie has dissolved. In special proceedings, the best interest of the child or the incompetent is not just a catchphrase, it is the North Star. If you are a guardian, you are an officer of the court first and a relative second.